Tamil Nadu Chief Minister M.K. Stalin has established a high-level committee to review and recommend measures for safeguarding the state's autonomy. The three-member committee, headed by former Supreme Court Judge Kurian Joseph, is expected to make recommendations to achieve maximum state autonomy without harming the unity and integrity of the nation. It's also mandated to suggest ways to restore subjects transferred from state list to concurrent and look at measures needed to address the challenges states face in delivering good governance. Stalin's announcement comes almost 56 years after the first committee with a similar mandate was formed by his father and former CM M. Karunanidhi in 1969 under Justice P.V. Rajamannar. Justice Kurian Joseph, former Supreme Court judge, is joining us on the broadcast. Justice Joseph, congratulations on being appointed by the Tamil Nadu government on the autonomy panel, sir. Can you tell us how this idea was floated to you in the first place?
No, I don't have much background about this. In fact, the Honorable Chief Minister of Tamil Nadu inquired whether I would be willing to be part of or rather heading a committee which would look into this interstate relationships and matters and related matters. I said I'm only happy to do that in the sense that's part of my job, which I've been doing for last more than 4 decades, 4.5 decades now. So I said I will do it as a service. Only condition I put it to him that I will do it as an honorary service, not on remuneration. That's the only condition I put. And that is the consent I gave. Nothing much else.
Why do you think, was there a need then to adopt or appoint a state autonomy committee as was done by the Tamil Nadu CM? Since this term has of course been used, can you help us understand it a bit better, sir?
Not a state autonomy committee. This is a committee. If you want to read out, I will read out the things. The committee shall examine and review the provisions of the Constitution of India and existing laws, orders, policies and arrangements that bear upon union-state relations in all spheres. Committee shall examine the existing provisions of the Constitution of India and suggest necessary measures for restoration of subjects to the state list, which were gradually transferred to the concurrent list. The committee shall suggest suitable measures to address the challenges faced by the states in delivering good governance. The committee shall recommend suitable measures to secure utmost autonomy to the states in the realm of executive, legislative and judicial branches without prejudice to the unity and integrity of the country. The committee shall examine and furnish reports by keeping in view of the recommendations of the Rajamannar committee, other commissions and union-state relations and also various political, social, economic, legal developments in the country from last 5 decades. So there's nothing to do with the state autonomy only, but state autonomy is something which they have mentioned in one of the terms of reference, but it's not an autonomy committee. After all, this is a federal governance system, no? So there is nothing called absolute autonomy, but there is a theory of a check and balances where you have to maintain the unity and integrity of the country, but at the same time, India being a union of states, the states also should have their own respective spheres of permissible autonomy which they can enjoy without any interference. This is what I have understood.
Can you explain to us a bit better, sir, about how this committee then would work? What process is going to be followed and when could we expect the final report?
The first committee in this regard was set up, I think, the former Chief Minister of Tamil Nadu itself, because Tamil Nadu has taken the initiative. Late Mr. M. Karunanidhi, which led to the Rajamannar committee. Then there was Sarkaria committee. Then there is Justice M. Bucci committee. So there are 3 reports before us. We have to look into those reports. How far the recommendations of those reports have been carried out or taken forward to their logical conclusions for the better governance of a federal structure of the country. And we hope to do an interim report because they expect to give us an interim report by at least by the beginning of next year and the final report within 2 years. For me, it's a part-time service. It's not a job. It's not a full-time assignment. I have made it clear. Because my full-time assignment, as I do here, is in Delhi I do my arbitration, mediation, consultation, etc. But this I do as an honorary service. So I sought time. So the Chief Minister has made it clear that it will not be a problem. That is granted 2 years. So we hope to have researchers, seminars, probably subject to what my members, we have the committee itself is yet to meet. Other two members, one Mr. Ashok Vardhan Shetty and Professor Naganathan. So we have to meet and chalk out what next we propose to do as to how to take it forward. But certainly there will be research papers and seminars and colloquiums on these aspects, just to know what the people have understood and what the constitution should be for the.
Yes. Also, do you think that the basis of your study and findings would help strengthen India's federalism? Would it also help other states as well?
Hope so, because it's not meant for the study of Tamil Nadu only. As I understand, Tamil Nadu has taken the initiative, as it did earlier also, and we must appreciate that. Both the initiatives came from Tamil Nadu, and this will just not meant for Tamil Nadu, it's meant for the whole country and the states in the country.
Yes. How do you then see the Supreme Court's judgment, which laid down timelines for governors on granting assent to bills as well?
Wrong with that, I'm not able to find anything wrong in that, because nobody is above the constitution. The country functions in terms of the constitution. So if there is some constitutional functionary which does not permit the constitutional scheme of governance to function, then it is at that stage that the Supreme Court of India, as the guardian of the constitution, should step in and remind the functionaries as to how best they should function. And if they do not still listen, then to make them function. Because the constitution should not fail. The functionaries may fail, but the constitution should not fail. And it is for the Supreme Court to see that the constitution still is an organic document, and it will still be for the country, after country.
Now, the Vice President of India has questioned the Supreme Court judgment, though, accusing it of an overreach, in fact, and acting as a super parliament.
I don't think that there is any the Vice President actually meant so, in the sense he was formerly a designated senior advocate who was practicing in the Supreme Court, and he knows very well what the functions of the parliament are and what is the function of the court is. Because what the constitution is, it is for the Supreme Court to say. So if there is some constitutional functionary which does not function in accordance to the constitution, the Supreme Court should always point out that aspect. If you remember, this came for scrutiny before the Supreme Court earlier also in S.R. Bommay's case, when the elected governments were the assemblies were dissolved. Against that presidential order, those governments, state governments came to Supreme Court. That led to the S.R. Bommay, the famous case, S.R. Bommay case, in which Supreme Court has made it very, very clear that if the powers are entrusted to a constitutional authority for achieving a particular purpose, and if the concerned authority under the guise of attaining the said purpose uses powers to attain an impermissible object, such use of power cannot be acceptable, or you cannot say that it cannot be questioned. It should be questioned, because everybody is bound to function under the constitution.
Now, he's also criticized Article 142, in fact, even comparing it to a nuclear missile. How do you see these observations, and what was the objective of Article 142?
I don't want to comment on his comment, but I can only say Article 142 is meant for doing complete justice. So in a situation where the Supreme Court felt that a situation has arisen and a stage has reached where it is in the interest of the justice and interest of the constitution and interest of the governance of the country that its power, repository power, should be invoked. It is well within his powers to have exercised that power in doing complete justice. Otherwise, again, it would have led to again time-consuming process, and the same authority being subjected to mandatory directions. So probably the Supreme Court really honestly wanted to avoid such a situation and see that there is, because you cannot defeat the constitution by delaying the process. But if somebody, a constitutional functionary, is permitted to defeat a constitutional purpose by delaying the process, that is the end of the constitution. That should not be permitted. It is in that context the Supreme Court, in fact, rightly invoked, according to me, Article 142.
Right. There's also criticism now coming in saying that even usage of the term state autonomy would be undermining the union government. How would you respond to that?
At least I do not want to think so, because India is a union of states and Tamil Nadu is also one of the states in the country. So unity and integrity of the country, which we even speak from the very preamble of the constitution, is an integral country, and the states are part of it also. So the autonomy means autonomy to the extent permitted in the constitution. If that autonomy that is permitted in the constitution is not enjoyed or is not permitted to be enjoyed by the states, then the committee should examine why and what are the blocks, and those blocks should be removed, and the state should be made comfortable to the extent the constitution permits them to be autonomous. For example, very simple, state list is that permits autonomy for legislation. So there are certain things where there is a constitutional scheme which actually contemplates autonomy for the states, and that autonomy should not be permitted to be interfered with. Probably that is the message that is given in the recent.
Yes. Do you feel then that the state, union and concurrent lists are open for a review in the constitution?
Constitution is an organic document. It grows with the times, So once you say it's an organic document, it grows with the times. There's no harm in revisiting and restating or reviewing the constitutional scheme of the relationships between center and the state.
All right. Justice Kurian Joseph, appreciate you joining us, taking time out and answering our questions.